I want to thank you for joining us for our first Dauphin County Bar Association Riverfront chat. My name is Tracey Lewis, and I'm a trial lawyer here in central Pennsylvania. My firm specializes primarily in personal injury law, and I have the distinct pleasure and honor of serving on the Dauphin County Bar Association board. And I'm extremely excited to be a part of this first ever Riverfront chat. These chats were an outgrowth of the association's desire to be more visible and relevant to our community. And we brainstormed and thought about, hosting these chats, and it might be a way for us to open up a dialogue with our community to see how we could become better community partners. So we're going to be recording this session, and we'll post it later to our website for anyone who was unable to be with us today. We'll assume that your continued presence on the chat means you acknowledge and agree to the session being recorded. Before we begin, I really want to take a minute to thank our wonderful Dauphin County Bar Association team. Although small in numbers, this group's passion for the Bar Association's mission routinely has them accomplishing things that really should take an army. And today's event is just one example of that. Literally, we thought about these chats just 2 weeks ago, and here we are, more than double the number of people that we thought would join us. And I want to say thanks to Tracey S, who's our executive director, our fearless leader. She's only been in her post for over a year, and already her vision, attention to detail, and commitment to excellence is being felt across the association. And next up, we have Bridget Hilbrish, who's our continuing legal education coordinator, newsletter editor, Dauphin County reporter. I mean, she does it all. And we're grateful that she wears so many hats, and we're grateful to have her. Next up is Sandy Ballard, and Sandy is our pro bono public relations coordinator. She has more energy in her pinky finger than many people have in their whole bodies. And when I was a younger lawyer in Philadelphia, I met Sandy, and she was one of the first female partners in the larger firms to say, this isn't working out for me. This firm life is not working out for me. I want to do something else. And Sandy went on to establish what is now Philadelphia's largest homeless advocacy program. So she was an inspiration to me then, and she continues to be so with her passion for community service. And last but certainly not least, we have our intern extraordinaire, with Miss Winifred Gutner, who is, Winnie is on loan to us from the UC Berkeley compliments of COVID-19. And so she's responsible for the Riverfront flyer that announced the chat to everyone. Ladies, just thank you so much for making this happen. We have a great panel today, and I just want to get into introducing each one of them. So first off, on the team, we have Victoria Edwards, who's a graduate of Penn State Dickinson School of Law class of 2005. She, while in law school, interned with the Honorable Sylvia Rambo of the Middle District. And she's a certified specialist in the practice of workers' compensation law by the Pennsylvania Bar Association section on workers' compensation law. She's also defends real estate licensees with regard to claims involving a failure to disclose, a breach of fiduciary duty, general negligence, and other causes of action. Victoria has also practiced before the Environmental Hearing Board, and in 2016, she was recognized as a rising star by the Super Lawyers. She's also proficient in Spanish and Portuguese. And Victoria, what led you to learn both Spanish and Portuguese?
Well, my mother is Brazilian, and her family immigrated to Brazil from Spain. So the family just speaks both languages.
So, por favor, de hola en português.
Eu quiero que todo el mundo tiene un bien experiencia aquí en nuestra clase de compensación de trabajadoras.
Awesome. Now tell us what you just said.
I said, let's all have a wonderful time here in this class of workers' compensation.
Awesome. Thank you so much. Dennis Kurdzic. Dennis was born and raised in Frackville, Pennsylvania. His parents, both educators, instilled in him from an early age the value of hard work. He followed that path of hard work and earned a scholarship to Bucknell University. After graduating, he remained in central Pennsylvania and attended the Dickinson School of Law. He's an active member of the Pennsylvania Association of Justice, the Pennsylvania Bar Association, and the Schuylkill County Bar Association, and a member of the Pennsylvania Elks. He also stays active in the local community by coaching youth sports teams through his involvement with the YMCA and the Central Dauphin Area Basketball Association. He approaches his work with passion and enthusiasm, and he's proud to represent injured workers throughout Pennsylvania. When he's not in the office, he enjoys playing basketball, golfing, being active along the Susquehanna River, and spending time with his parents and 2 sisters. So, Dennis, tell us about your coaching activities. What ages and what sports?
Unfortunately, I haven't done that in a few years, but I was a very involved basketball coach for many years, both in the Lewisburg and Milton area, and then down here once I moved down to Harrisburg. I think I mostly coached 5th and 6th grade boys. It was a great opportunity to give back to the community.
Awesome. Next up, Steve Ryan. Steve is an attorney with Martin Law, and he is also a certified specialist in the practice of workers' compensation law by the Pennsylvania Bar Association section on workers' compensation law. He's an active member of the Pennsylvania Association for Justice, the Dauphin County Bar Association, and the Pennsylvania Bar Association. He received his law degree from Widener University School of Law in 2007 and his undergraduate degree in English from Brooklyn College in 2002. During law school, he was a senior staff member of the Widener Law Journal. Outside of work, Steve loves spending time with his family and is an avid practitioner of Brazilian Jiu-Jitsu. So, Steve, what's the main benefit you've derived from practicing Jiu-Jitsu?
I started when I was a defense attorney and I had a lot of billable hours to bill and very little time to exercise. And I used it as a means of losing weight originally. I think I lost about 30 pounds within the first year that I was doing it. And that was the reason that I went into it. But the reason I stayed is I don't know of a better exercise for both your mind and your body at the same time. It's like playing chess, but running on a treadmill. It's the best way I can describe it.
So basically, as a defense lawyer, you had to multitask. So you were working out and working your mind at the same time.
Yes.
Awesome. Our last participant, panelist, who is the chair of the workers' comp, and he was really instrumental in helping us put all this together, is Jonathan Spadea. And I hope I got that right, Jonathan. He's born and raised in Central. Yeah, I nailed it? Mm-hmm. Awesome. Jonathan's born and raised in Central Pennsylvania. He's a partner at Cartwell Law Offices in Camp Hill. He works exclusively with employers and insurers defending workers' compensation claims and employment law matters. Prior to working for Cartwell, Jonathan clerked for the Dauphin County District Attorney's Office. Outside of the office, he's kept busy by his 3 young children. He's an avid college football fan and a proud supporter of the Harrisburg Humane Society. So, Jonathan, who's your favorite college football team and why?
It's tough in my house, but I'm a Notre Dame fan through and through. My entire family, including in-laws and parents and cousins, are Penn State fans, and I know I'm in the heart of Penn State country, but I wear my blue and gold proudly on Saturdays for sure.
I was going to say, if you hadn't put that last part in there, you might be endangered. But I think Central Pennsylvania will take a little easy on you.
Thank you.
All right. So before we get into the questions and answers session, I have to put another disclaimer on the record. The opinions our panelists are going to give should not be considered legal advice. Much of the law is fact specific, and you'll need to speak to somebody about your particular case. Remember, this is not meant to be legal advice, but rather a legal discussion, a marketplace of ideas. So first question, I'll kick it off, and then you guys can be free to jump in and add as you see fit. But I thought we would start with some basic questions. First off is, what is workers' compensation? And then prior to COVID-19, how was somebody eligible for it?
Thanks, Tracy. I'll kick things off here. And just to kind of piggyback off of what Tracy said, we want everyone to participate as much as they can. There is a chat function. We will be monitoring the chat. So please, if you have questions, ask them. As Tracy noted, it's hard to give specific legal advice in this format. So our goal is really not to do that, but to give you information. We have sent out a resources list that lists a lot of links to various government websites where you can find more information, as well as our own bios and links. And that does include the Dauphin County's lawyer referral program, where you can find an attorney if you don't have one. But with that said, please feel free to use the chat function to ask questions on any topics that come up. We are going to try and focus on workers' comp and unemployment. We get it. Clearly, there are a ton of related employment questions or questions that intermingle and swim through workers' comp, especially in this crazy time of the pandemic. But we really want to focus today on the workers' comp aspect, because that is really our wheelhouse. And, you know, hopefully if we get a lot of other questions, we can spin this off into future fireside chats on different topics. But yeah, to piggyback on and bring it back to what Tracey said, in general, workers' comp is a system designed to make up for, replace indemnity benefits, wage loss benefits, and medical benefits if you sustain an injury at work. That's in its simplest form. And at least in Pennsylvania, there are a couple of different ways to go about it. And I will again note, I do defense work, Victoria does defense work, Dennis and Steve do claimants, primarily and exclusively claimants work. So we're going to have a back and forth conversation. So I'll kick it over to the claimants attorneys just to discuss your input on the types of claims, types of options you would have for a claim, given the coronavirus COVID-19 parameters.
Well, I'll tell you, the analogy that I usually use for my potential clients when they walk in the door to help explain the workers' compensation system is to have them imagine that they were walking on a high wire, and when they're on that high wire, they have all of their health and they have all of their wages, and life was as good as it was for them. And then they fall from the high wire. They usually have some type of injury. They lift the box and they feel a pop. They slip on some ice. And now we're in a new world here where there's obviously a communicable disease that we're discussing. They would otherwise fall to the ground. But the law provides a safety net called workers' compensation. And in that safety net, you are provided with usually about 2/3 of what your average gross earnings were. And in the typical case, reimbursement of your medical benefits. In some COVID-19 cases, death benefits could become available. And I think the way I'm thinking about COVID-19 cases, and I'll let Dennis give his input, I look at them in two categories. The first being those directly impacted by COVID-19, those that have been diagnosed with it, and for unemployment compensation purposes, maybe those caring for somebody who has it. And then there's the collateral damage of the COVID-19 crisis, those who don't have a diagnosis, but their jobs were affected by it. Both those who are diagnosed and those whose jobs have been affected could potentially have access to the workers' compensation system, in addition to some of the other benefits I know John's going to share with you later. So, I don't know if Dennis had any.
Yeah, and I'll tag in on that. And at this point, most of the questions I've gotten through my office come down to COVID diagnoses, COVID concerns for exposure, things like that. I think one thing that I found is a lot of people don't realize that the COVID situation leading into governor's orders to close businesses may open them up for benefits they didn't know about. People don't know that effect. And that's why it comes down to people like Steve and I to inform them of that. The problem is, if they don't know, they're not necessarily going to reach out to an attorney. And
yeah, if I can jump in real quick just to go through that, Dennis, thank you. I think now's a good opportunity just to kind of talk about what some of those benefits are. I think a lot of people have heard of or are familiar with, the extra $600 that you can get from the federal government with unemployment compensation. So if everyone can bear with me, I'll try to speak in plain English and keep the legalese out of it. But I do think it's beneficial just to talk about some of the benefits that are out there. These were all passed pretty quickly and early on, so it may have gotten blown under the radar. But the first one is benefits that really affect FMLA. So family medical leave, basically in Pennsylvania, protects your job if you have a qualified condition for up to 12 weeks. a very common one is if you're pregnant. And my wife is pregnant right now, is about to go out with the baby. And typically, FMLA protects your job for up to 12 weeks. That is usually without pay. But one of the major differences that Congress passed here is basically what I'll call FMLA plus or FMLA with pay. There are a lot of specifics, and I don't want to bore everyone and go through them, but if your employer has less than 500 employees, you can get paid for a COVID-related issue. The amount can vary depending on whether you have a diagnosis, have been ordered to stay home, or you think you may have the symptoms and you're trying to get diagnosed, or if you have to care for a loved one who has the disease and has to stay home in quarantine. There are a lot of different factors. If there are specific questions, we can get into them, but in general, there are paid leave benefits available to employees if they have a qualified condition under these FMLA plus type benefits. If you have questions on those, you can check out some of the resources on the list. I would also contact your employer's human resources department to see how you go about applying or getting those benefits. But important thing to know is if you qualify, the employer cannot take your other leave first. So they have to do these special benefits. So that's really one category. The second one is what was passed under the CARES Act. This is where that $600 of unemployment comes into play. That is important. I want everyone to know right now that if you are getting those benefits or if you are applying for them, they run out at the end of July. Congress is talking about expanding or adding on another round of stimulus. It's going back and forth. I would just tell everyone, don't count your money until you have it in hand. Who knows what they're going to come up with, but those benefits as of this time will stop. With that said, the CARES Act had a number of other benefits available. A lot of them from the employer side, if there's any business owners or representatives from the business community, there are a number of very significant and powerful tax benefits that are available to you, whether they're credits or deferral programs. I would recommend that you reach out to, if you have an accountant or someone who specializes in tax law. Unfortunately, math is not my strongest subject, so I'm going to have to defer on those topics. But those are really some of the main benefits that may be out there. And in some cases, depending on the type or severity of your disease, you may be able to get more going one of those routes, the FMLA, the unemployment, than you would for a COVID-19 case. So I want to turn it over to some of the other attorneys just to pose a hypothetical and see, get your input. Does it matter if a client walks through your door, Steve or Dennis, and they have just a very minor case, or they were out for 2 weeks and back, versus someone who has a severe case and was hospitalized? Do you assess it differently?
I think we sort of have to. I don't think the proof changes necessarily. You still, if you're filing a claim petition on workers' compensation, you have the burden of proving that your injury is work-related, generally. So the proof doesn't change, but the value of the case changes, obviously, based upon the duration of benefits and what medical benefits may be owed. And beyond that, if someone is out of work for 2 weeks and they get the family first pay or they get some other sort of benefit, there may not be much of a benefit to them for filing a workers' compensation claim. So it's not to say I wouldn't take a case like that, but that's something I would definitely explain to the client so that they understand what their best case scenario is for bringing a claim.
I would agree. I think on the non-serious side, if we're talking about somebody that has an illness for 2 weeks or maybe slightly longer than that, what I'm seeing in some cases is that the combination of some of their unemployment compensation benefits are paying them more than what they were earning in some cases, at least their average of what they were earning. And if you have a minor case, it's going to take about 9 months to a year if you have a denied claim to go from start to finish in the workers' compensation process. And so you have to decide whether the benefit that you're going to gain from going through the time and the stress of being in court and people like Victoria and John cross-examining you on the stand, whether that's worth it to you when you have the ability to go back to work and you're made whole, in some cases, even more so. I think there are some things that can come up with interactions between insurance companies. For instance, if it's some clear case of exposure, and that's a tough thing to say because I think exposure to COVID-19 is something that's very arguable right now. There are some private health insurance companies that might say this is work related and the workers' comp carrier should pay for this. And in that case, you may have, it may be some benefit to getting into court to proving that, but I think that's very rare. So on the minor side of the illness, most folks are probably better off with the benefits that they're going to get outside of the workers' compensation system. But I would add, because it's a safety net and because the disease is an open question right now in many respects, I know we're all reading the news and you're hearing different things in different places. It does make sense to report it if you think that it happened at work. So when we talk about filing a claim, there's really two steps. There's when you tell your employer that you think that your exposure is work-related, and when they deny it and you have to go to court. I think it's very important if you think you've been exposed to it at work to report it as soon as you can and in writing if you can.
Yeah, I would like to piggyback on that and say that I think notice is extremely important for a couple of reasons. First of all, if you don't report your workers' compensation, let's say it's COVID-19 exposure, you lose the right to make a claim if you don't report it to your employer within 120 days. And with COVID-19 being a novel virus, we don't know what kind of impact the virus might have on your body, months or years down the road. So I think it makes sense to provide notice, obviously for that reason. And then secondly, you want to notify your employer so that your employer can notify your co-employees, not necessarily that you have been diagnosed, but that they can be placed on notice that there's exposure in the workplace and that they should take precautions, potentially quarantine for 14 days or get tested themselves. So there's a couple of reasons why notice is extremely important, especially in a communicable disease situation.
Thank you. Victoria, I guess from the defense perspective, and I imagine it's a rare opportunity for most people to have both the claimants and a defense attorney here. I don't know if you have, but if you see a COVID case come across your desk, what are some of the questions that you would be asking, or what are the type of things from the defense side you would want to see to determine whether or not this was actually contracted at work, or what we would call the defenses, quote unquote?
Well, the first question that I ask my employer is, what type of position was this individual in? Are we talking about a nurse? Are we talking about a frontline worker who was coming into contact with people that we know were COVID positive? Because I think that makes a big difference. It's going to impact the claimant's burden, because if they can show that they know that they were in contact with an individual who was COVID positive and they then contracted the illness themselves, I think that they're going to be able to have an infectious disease specialist connect those two dots. And so I asked that question, what type of employer are we talking about? And whether or not there was an obvious exposure. Even if it's obvious, I think the employee still has to prove that they were exposed and that their diagnosis is related to their work activities. But I think that goes a long way to showing that there was a connection.
Yeah, and I think you're kind of hitting the nail on the head there. I can tell you, at least from my perspective, is the same. That proof of where this disease was contracted, I think, is going to be key. The nature of the disease, as we've all pretty well heard by this point, is that it can remain asymptomatic for up to, I believe, 14 days. And as we go green here in Dauphin County, Cumberland County, as things open back up, individuals are starting to go out more, go out in the public. And I can tell you, those are going to be questions that I would ask my employer. Do they know? And certainly if it gets on the same claimant, you know, what are your other activities? Where are you going? Did you go anywhere for the holidays? Have you traveled? Do you go to the grocery store? Have you been to certain quote unquote hot zones, parts of the state where we know there are a lot of contractions of the disease? And I think all those are going to be very important questions, and the answers are going to be very important, because in my opinion, I think it's going to be difficult in some cases, if not impossible, to prove definitively this disease was contracted at work. And I think, Victoria, you kind of hit on it when you said, you know, the types of occupation. And I'll throw that to Dennis and Steve. You know, why would that matter per se, or in a workers' compensation case? And does that come up in a different type of claim under occupational diseases?
Hey, Jonathan, let me jump in here a little bit.
Sure.
So, you know, I just heard from the defense that, and we know that COVID is, I mean, there's a lot of uncertainty around how it's caused, where it comes from, and that type of thing. And I just heard from you and Victoria that those are the kinds of questions you're going to be asking. So from the plaintiff's perspective, it seems like, you know, is this a winnable case? I mean, do you even take these cases? Because it seems like, you know, the defense is going to be saying, you know, you just can't link those two together, causation and you getting COVID. So what, you know, how are you all approaching these kinds of cases?
I think that we have to acknowledge that there's, you know, an elephant in the room. Historically, under the Workers' Compensation Act, there was a lot of argument about whether a disease could be considered an injury. And over time, the definition of injury has been expanded to include diseases, communicable diseases in particular. But it doesn't alleviate the difficulty in proving it. And so when somebody's sitting in my office, and in particular with COVID-19, I think occupation matters more than the typical case. If you lift a box as an IT guy or an economist, you're gonna have a work injury just like if you lift a box as a meat packing employee. But in the COVID-19 scenario, you know, I'm interested to know, do you work in a meatpacking plant? Are you a nurse? Are you in a healthcare environment? How close are you to your coworkers? Meatpacking plants in particular, the employees tend to be very close to each other, because I'm evaluating two things. Number one, can I prove factually that this person was exposed to COVID-19? And there's a bigger, perhaps a bigger problem. Can I make the link medically? And there's some case law, there's a famous case called the kiss of death case, or what I refer to as the kiss of death case, where an individual went into work feeling fine, and he went home feeling very bad. He ultimately died. And when they did testing, it was found that he had strains of meningitis in his system, some form of meningitis. And in this particular case, the employer tested his co-employees, and they were able to find somebody who had that strain as well. And factually, the claimant was connected to that person because as she was leaving for maternity leave, he gave her a kiss on the cheek. So that links him factually to exposure, but then you need a medical professional. And I'll let Dennis talk about that. But to give you an analogy, I always tell my clients that the medical evidence is the gasoline in the vehicle of your claim. And attorneys on my side can really only drive it as far as your doctors are allowing you to. I'll let Dennis talk about the medical side.
I agree. I mean, the case is in almost every situation only as strong as the doctor's opinion. Now, some doctors are great at connecting the dots. Some doctors I take depositions of, I have no concerns going in because I know they've seen this claimant or their patient 10 times, they performed surgery, they've tracked them throughout, and they've been through the process, so they know the kind of questions, they know the kind of pitfalls and things to avoid when testifying. And they can connect A to B to C and get us a medical opinion that's going to stand up and have a judge find that to be credible. In these cases, I think it is more difficult. It is more unsettled. This is a newer type of situation. And I think there will be medical experts out there that can give opinions and say, within a reasonable degree of medical certainty, that they believe this exposure happened at work and this is what caused the ongoing disease. But I don't know who those experts are at this point. I don't know what that evidence is going to look like. And as we've hit on, it's going to be very, very fact specific. And I think certain facts, I don't know how readily available they're going to be. An example we've talked about in preparing was, so if you have if you have a claimant who tests positive and there's some knowledge that other people at the work site tested positive, what kind of information can you force the employer to give up? Can you get the employer to tell you who those other coworkers are that tested positive, what departments they worked in, what sort of interaction they may have had with your claimant? I think all of those things are going to be important facts that might be developed. What does the defense side think about those facts?
Well, let me jump in here real quick. So after you guys answer that, I have a follow-up question that came in from somebody related to this kind of uncertainty in the workplace.
Sure, I'll give just a very brief response to Dennis's question. I think it's important to remember with the employer, there are a lot of federal employment laws and obligations they have. One of them that is very strongly protected is the right to employees' privacy, especially with respect to medical conditions. So I would advise any of my clients, and just note in general, I imagine employers are going to be very reticent and will challenge any types of efforts to get subpoena or motion for specific identifying information. There may be, we may see some places of business that will do temperature testing, whether through an infrared device of employees, and send them home. Do they keep that data? I don't know. That might be relevant. I may have a tougher time keeping that out of court. But I can tell you in general, and Victoria can briefly add if I'm wrong, I think that employers have a lot of obligations on their own end, and they cannot legally give up medical information of other employees under the HIPAA laws. But I would say, just quickly note that they do have other obligations under OSHA. So if they know that an employee is sick, they have to notify the other employees that, hey, you may have been exposed, you may have been in an area that's exposed. And I think if I was a claimant's attorney, those are the types of questions and information that I'm fighting really hard to get, whether through deposing the employer or representatives. But I don't know if you had anything to add, Victoria, before we can check in with that question.
I would just say that if I was a claimant's attorney, I would absolutely subpoena the employee's personnel file to see if there was any information in there that showed that there had been an exposure to COVID. And so that would be my first thing. Subpoena the employee's file, personnel file, and get all that documentation.
Thank you.
Yeah, so the question I had was, we've been talking about basically people who have to work at the job site, meat packing, package delivery, those blue collar jobs. But so given the uncertainty, there was a question that came in from one of the participants, the attendees. It says, I have an employee who's been able to work remotely successfully. I really like having this person in the office, but they said they're scared of getting COVID-19 and that they're at an increased risk of getting it due to underlying health conditions. Do I have to let this person work from home, or can I require her to come back as long as I follow all of the CDC guidelines? So my question to you is, given the uncertainty, if this person is to come back and, she's documented or he's documented that I was not really wanting to come back, but I was made to come back, and they contract COVID-19. How does that factor into, this paradigm that we're talking about in terms of discoverable information and what happened in the workplace and was there exposure there, that kind of thing? And does an employer open themselves up if they kind of force people back before they're ready?
Yeah, I can, real quick from the employer side, certainly, I would say that goes the same with any work injury. We see this come up a lot when a claimant has some limited ability to work, some restrictions, can't lift over 20 pounds, and you bring them back. There is always a chance that they re-injure themselves or get hurt further. If I was advising the employer in this situation, I would want to know a couple of things and have a couple of questions, because I think in general, just from a human perspective, if a judge hears about the quote unquote evil employer and there's a lot of seemingly bad, uncaring actions, especially in the midst of a global pandemic, I think they will not look too favorably on that employer. However, there are some jobs that just cannot be done remotely. In this specific situation, I might tell the employer, maybe we want to be as flexible as we can. If you don't notice necessarily a dip in production or the quality of the work, maybe we accommodate, maybe we allow them to work remotely, maybe we try a staggered schedule, 1 or 2 days here or there. But I am stressing, at least to all of my clients, that, to the extent you can, be accommodating, because at the end of the day, no one wants to get this disease. No one wants to be exposed to it. But there are certain times and situations where that job, the employee, it just cannot be done at home. So there's a couple more questions I would ask, but I don't know if the claimant side, does that factor in, any actions by the employer?
I would say this is getting more into the area of employment law, and I'm under the Workers' Compensation Act. There's not anything that I'm aware of that would address that issue one way or the other. As a general matter, when I'm talking with counsel that do practice employment law, I know that the employee has a right to request an accommodation, and then that starts a whole process. And one of the larger questions is going to be, can you accommodate that employee from working from home? And if you can, just from my side of the V here, I don't know if liking having them is enough. If you merely liking having them physically present is enough. I don't know. It would be a great topic for an employment lawyer.
Awesome.
Yeah, I would just say, in that real quick, in this situation, I would certainly, if I'm advising the employer, I'd want to see some medical documentation, if that's important. What you can't specifically ask, what are your diseases, or what's your condition, but do they have a doctor's note that says they're at higher risk, for these diseases and the infections? But yeah, that's definitely a good topic for another chat on some of the employment side.
And I would add.
Awesome.
Mm-hmm.
Go ahead, Derek.
Yeah, I would add to that, and John sort of hit on it. Generally, I had a similar question. A client of mine who was working light duty, can't work remotely, could only work in the office, but she's immunocompromised. She got a note from her doctor saying that she had to work from home for, several weeks, and they were able to accommodate that. So I think you need medical documentation. That's going to go a long way. And beyond that, from both the employer side and the claimant side, I think communication is the key. You need to talk to each other. You need to see what you can do to make it work. But in certain situations, I think if the job has to be done on site, I think the employer is going to be in a position where they can make that sort of demand. And if you're caught in that situation, that's when you have to reach out to an employment attorney, because they can really go through the fact-specific situation and give advice.
I'd say one more thing.
Awesome.
I'm sorry, just one more thing. For the person who's sitting at home and maybe has a compromised immune system, and you're wondering, should I quit rather than go into work? Quitting can have an impact in workers' comp and under employment comp law. So I would be counseling people, if you quit, you have to do so with your eyes wide open, in that you may be giving up some access to benefits.
And
Okay,
one
so
other thing, sorry, Tracy,
no, go ahead. Go ahead.
I think part of your question was, does the employer open themselves up to potential liability by having the person come back, and then if they contract COVID? Unfortunately, from my perspective, I don't think they do, at least with the current status of the law.
Okay.
Workers' compensation is the sole remedy that you can pursue in almost every case against your employer for an injury occurring on the job. Because
Awesome.
of that, I don't think the fact that you did not want to go back, the claimant didn't want to go back to work, but was forced to go back to work, then contracts COVID, I don't think that changes the burden of proving that it's a work-related condition.
Mm-hmm. Okay. So we talked about the potential for filing a workers' compensation claim and the proof that's required. Are there any other downsides to pursuing a workers' compensation claim?
If I can jump in real quick, I think I see a question on the chat. If I can just address real quick, Tracy, from Pam asking, is there a legal or medical definition of quote unquote compromised medical condition that would be more supportive of a claim? At least under the workers' comp law, I don't think there is, a definition of compromised, but I think this is a very good question for the medical experts, kind of what Steve and Dennis were talking about, whether that be their own personal doctor or an infectious disease expert. And I think it would go to, and you guys correct me if I'm wrong, all of the conditions that we've heard about. I think, if you have pre-existing pulmonary issues, diabetic, age group, all of those things I think would go into play. And whether or not that makes the case more likely or not, I think those are some of the types of questions you would look at. Dennis, Steve, any thoughts?
I would think that if a claimant's immunocompromised, and this is, maybe this is getting into more medical than legal, but the way I would look at that is that goes more to the severity if they're exposed to the condition than the likelihood of exposure. So I think in that way, that is something that a doctor would address, because if they're immunocompromised, they're exposed to this condition, their results or potential for recovery is probably going to be worse.
I would agree. It doesn't necessarily, the definition wouldn't necessarily impact the liability of the employer in the workers' compensation side. The employer has to take the injured worker as they arrive with all of their comorbidities and pre-existing conditions, and we'd be arguing about how bad it is after their exposure.
Great, thank you. Please, if there are other questions, we love answering them as best we can. With that, Tracy, I'm sorry to cut you off there. I know you had a follow-up question. Could I ask you to restate it?
No, it was, so we've talked about workers' comp, and we've talked about, the challenge with these kinds of COVID cases. Are there any other downsides to pursuing, these workers' compensation claims? Or is there another remedy or another way that somebody can kind of protect themselves if they believe that they have COVID and they can't prove it medically, or they're, concerned about getting COVID?
So I would just say that provide notice to your employer whether or not you're going to make a claim or not. Number two, I would say that the employer cannot retaliate against you for filing a claim for workers' compensation. So you shouldn't be concerned that you're going to lose your job simply because you made a claim. So that would be the two things I would say about that. And are there other avenues for compensation? Yes, there are. There's unemployment compensation. There's the CARES Act, additional $600 that you're potentially entitled to if you're unemployed. So yes.
I would say whether there's a downside would largely depend upon the person who's sitting in the chair in front of me. They have to have the ability to withstand going through some litigation over the course of some months. There's some costs associated with the litigation in terms of finding doctors who are going to testify on your behalf. And, you may want to go back to work in the interim. And if those are the cases, it's maybe you don't want to bring a comp claim and just move on with your life. Some people do that.
I would agree on that last point Steve made. I think, unfortunately, sometimes the filing of a workers' compensation claim can sour an employment relationship. while the employer cannot retaliate against someone from bringing a claim, it's not always pleasant if that's hanging out there and the person goes back to work. I would never discourage someone from bringing a claim for that reason, but it's something that I try to make clear to clients. They can't retaliate, but that doesn't mean they have to be pleasant to you when you go back to work.
That's unfortunately.
Yeah.
So this is another question that's not necessarily workers' comp. It's more on the unemployment compensation. Here was a gentleman. He says, "I'm currently getting unemployment compensation, and I will be getting some severance pay shortly. How do I enter that money into the UC website? There's no place to list that from what I see. It asks if you have holiday pay or vacation pay, but not that. Thanks in advance."
So this is one, unfortunately, I would have to recommend that they call the UC office where they file that. There's a resource on a resources list is the PA government UC website. You can get numbers there. That's the specific question I don't know the answer to. I do know if you get a severance that does reduce the amount of unemployment you get. But as far as the specific mechanism of how to input that data, other than being patient, and I want to stress, you're going to have to be patient anytime you call a governmental office. Just know that ahead of time. I would just have to recommend that they call the UC office directly and see if they can help troubleshoot that.
Yeah, so follow up to that is the severance typically reduces the Pennsylvania unemployment compensation. Do we have any knowledge about what happens with the federal $600 that is being given? Is that affected by severance at all, if you know?
As far as I know, I believe that $600 is over and above anything you get in the state.
Okay.
I would probably have to do a little more research just to be 100% sure, but I do know that one of the arguments we're having currently, the defense in the claimants bar, is with respect to workers' compensation. You cannot get, or you get a credit for receipt of UC and receipt of workers' comp benefits, meaning if you get $500 in workers' comp and $500 of Pennsylvania unemployment compensation, you can't collect both at the same time and you get a credit. You only get one payment. There's a very live argument and debate happening right now as to whether or not this federal benefit, which acts like UC, it may be called UC, actually qualifies under those specific benefits. So I would my estimate right now is that no, that money is over and above and in addition to, but I probably have to do a little more digging just to be sure.
I'm glad this is recorded because when John and I are in court, I'm going to play that when he tries to assert credit. Just kidding, John.
Thanks, Steve. I did want to.
It's so nice that you could be civil. It's so nice that you could be come together for the Bar Association and be civil. Thank you, gentlemen.
Yeah, it's a pleasure. I always enjoy speaking with Steve and all my brethren on the claimant side. Real quick here, I know because we are starting to run out of time, I wanted to touch on something Steve brought up at the start and pose it to Steve and Dennis about the collateral damage cases that you're seeing, because it seems, at least from the defense perspective, these are much, much more common than, the typical, I'm filing a claim for a COVID-19 case. So I guess, what are you talking about when you're talking about these type of cases?
Right.
So I've gotten a few calls recently. I spoke to a client yesterday who had returned to work in a modified duty role about a year ago. He gets laid off in March, and then his layoff becomes permanent. Under my view of it, he's gone back to work with restrictions, with limitations, and there is case law to suggest that if the company shuts down or if his job is eliminated, that he's entitled to a reinstatement of his workers' comp benefits. So we filed a petition on that. Now, I've heard arguments from defense counsel on this, that this is sort of something that case law doesn't really provide for or apply to. This is a, once in a lifetime situation. I don't see it that way, but, we can disagree on those things and have a judge decide.
Yeah, I'll kind of just expound on the defense perspective, because this is an argument I've been raising, and it doesn't always make me popular, but just so that people are aware of, the situation here. As Dennis pointed out, if you, in normal times, in normal non-pandemic situations, if you have restrictions and the job's not there, you get reinstated. The argument here is basically workers' compensation was just never designed to accommodate a global pandemic. The pandemic is affecting both employers and employees adversely, and all of, I would argue, the case law surrounding these situations where a claimant is working with restrictions and goes out just don't apply. I can tell you that's not been a winning argument for me thus far. Steve and Dennis are both beating me up on the regular. Maybe Victoria puts it better and has a little better luck, but at least in my experience, the judges aren't very receptive, and I frankly can understand it because again, this is a global pandemic that we're going through, and no one likes to hear about those obtuse, broad, heady legal arguments.
Yeah, I think it's important for those who are listening and may have been laid off. If you had work restrictions when you were laid off, in my view, your employer has released you into the labor market at a disadvantage relative to somebody who doesn't have work restrictions. And you do have a claim, in my view, for workers' compensation benefits. Those benefits may be less than what the combined benefits are under unemployment comp, but they run longer and they're not taxed. So it is worth considering. If you don't have restrictions, if you are full duty and you're laid off, still talk to somebody. Your job may have been modified in some way or some change in your position that would give you an argument to have be traveling two roads at the same time to try to provide for yourself during these unique times. Either way, whether you file a claim for workers' comp, in most cases, you should, and you've been laid off, you should probably still file for unemployment comp and deal with any of the credits down the road.
One thing that you kind of just tripped my trigger here, Steve, one of the biggest differences and biggest benefits of filing a comp claim, none of the other programs or benefits will pay your medical bills. If it's a work injury, your medical bills are covered and the insurance company has to pay for.
See, John's frozen. I'll pick up where he left off. Under workers' compensation, your medical benefits, you pay zero. And you're not going to get that with unemployment compensation benefits or any of the other benefits that John had mentioned, to my knowledge, in the very least. So it's something to consider.
Co-pays with workers' comp, so.
Right.
I'm sorry, Victoria, what was that?
Yeah, Vicki, what did you say? Sorry.
I just said that there's no co-pays with workers' comp as opposed to private health insurance where you have to pay a co-pay.
That's correct.
Okay.
I think the other thing to keep in mind with pursuing a workers' comp claim or reopening a workers' comp claim if you're laid off is workers' comp often ends in lump sum settlements. And sometimes they can be sizable lump sum settlements. You're not going to get a lump sum settlement through unemployment. You're not going to get a lump sum settlement through pandemic relief. So it's worth reaching out, talking through your options, and capable workers' comp claimants attorney like myself or Steve will comb through everything and look for everything we can do to help.
Awesome. So we have 8 minutes left. I think we lost Jonathan. So
Sorry.
Victoria, are you back? Okay.
Sorry about that.
So here's one question. I was forced to close my business due to COVID-19. I reopened recently, but not full staff. And this might be an employment question, and if it is, just say that. I didn't lay anybody off, but I require them to use their personal or vacation time. Now they're telling me I can't do that. Can I?
Yeah, that's a tough question. It definitely gets into the employment side of things. Okay. I would caution the employer, if the employees were getting any of the FMLA plus benefits, they absolutely cannot use their vacation time. But in general, yes, you can, outside of this pandemic situation, and just, if employers do have some leeway to say, we need you to use a vacation day here or there. It is much more complicated now that we're in the midst of this pandemic. And I would just very, very well caution that employer to make sure, were these employees getting FMLA plus, because, one of the things from the employment side, litigation on an employment issue is drastically more expensive than a typical comp case. And the potential there, especially if there's a lot of employees, God forbid I say the word class action, there's just a lot of concerns there that are a little more fact specific, but I would just caution them to be very careful.
That sounds good. So basically the word of the day from all of this is to be passionate, to be, treat your employees, treat your employer like you'd want to be treated, because at the end of the day, it could get messy. I mean, we just have uncertainty, and, to just try to be accommodating. I think that's what I'm hearing.
I agree.
100%.
I would agree.
Yeah. Well, if there aren't any other questions, do you guys have any parting words? Well, how about this? Okay, go ahead. You have your parting words, and I think I might have a question for you. So go ahead.
Just one thing, we didn't really get into, there's a whole section of the Workers' Compensation Act that deals with occupational diseases. That's too long for a talk like this, but there is some legislation pending that's occupation specific, that if you are a first responder, for instance, or perhaps even an essential worker, you can keep your eye on, that may give you some benefit in court down the line. But other than that, I have no parting words, except thank you very much.
Awesome. Victoria?
No, I would just say thank you.
Spanish, Portuguese, or English? You take your pick.
I'll stick to English. I will say thank you for this opportunity. It's wonderful to get to speak with the community, about the issues that we're passionate about in our work. So thank you.
Awesome. Jonathan?
Yeah, again, just piggybacking what everyone said, thank you for your time. Please, if you have questions, need help getting an attorney, contact the Dauphin County Bar Association. Hopefully you have our resources page that can give you a lot of good insight and good information as well. And keep your eyes peeled for more of these chats coming down the road. Thank you.
And Dennis?
I just hope we started these chats out on the right foot, and they can grow from here. And honored and happy to be a part of it.
And my apologies for my internet. I think my 12-year-old's upstairs playing Fortnite, so I have to go.
So, in terms of starting out on the right foot, I asked us all to have a practice run yesterday, and then my fizzled out. But guys, thanks so much. This really was born out of just seeing resources with community so that people can have access to information. And the goal is that if everybody's educated and everybody knows what's going on, that our community is better for it. And so we look forward to these additional Riverfront chats. I think the next one, Winnie, when is our next one? Can you chime in here for me? Is this Sandy?
Yeah, our next one is Monday, June 29th at noon, and we'll be talking about bankruptcy and the possibility of getting some kind of fresh start with all the financial burdens people are facing. And then I'll just also add July 8th, right after the 4th of July holiday, at noon, we'll be talking about landlord-tenant issues, both in terms of renters, now that the moratorium or hold on evictions will be lifted July 11th, I believe. And you'll learn more about that, but we are concerned about people facing evictions after the beginning of July. And also for small landlords who may be struggling themselves as well.
Awesome. Sandy, you are my hero. I love you. Going forward, if you have any sessions that you think we should be doing, any information that you think we should be providing, please let us know. You have the email. We're going to be sending you a link to this video, as well as you already have, and it's in the chat. Patrice just uploaded it into the chat. So basically, tell us what you need. Tell us what you'd like to do or what you'd like to see, and we're going to try our best to get it to you. So thank you, everybody, so much for joining with us, and we look forward to seeing you at our bankruptcy session. Thanks. Bye-bye.
Thank you.
Patrice, do you have anything to say?
No, other than just thank you to everyone. Thanks to the panel, and we look forward to more.
Good deal. All right, guys. Thank you. Have a great afternoon.